Hello and welcome to a discussion of a very important and frankly breathtaking book, Terror Courts, Rough Justice at Guantanamo Bay. And joining us today is the author of the book, Jess Bravin, the Supreme Court reporter for the Wall Street Journal. Jess studied at Harvard College and UC Berkeley Law School. He's won the American Bar Association's Silver Gavel Award for coverage of law and terrorism after 9/11, and the Elizabeth Neuffer Memorial Prize from the UN Correspondents Association for reporting on the international criminal courts. And I'm pleased to say that he was part of a team from the Wall Street Journal that earlier this year received the National Press Foundation's Online Journalism Award for its multi-platform you couldn't get any tighter than this deadline award for its coverage of the Supreme Court's Affordable Care Act decision. I'm Bob Meyers. I'm president of the National Press Foundation. So, Jess, this is an exciting behind-the-scenes look at a legal experiment that really challenged American standards of fairness. So I'd like you to initially walk us through the origins of the book and then of the terror courts.
Sure. Well, the book originated because as a newspaper reporter, sometimes you cover a story that goes on for so long and has so many details that you can't really tell it in even a long-form story that we might have in our paper. You can't tell it with the sort of nuance and context that it requires. I mean, the stuff, there's always, you hope, there's good stuff left out of a newspaper story, so only the best stuff appears in it. But here we're talking about, really, I thought, a legal development of historic proportions, and one that really deserved a book-length treatment. After writing on this topic for a number of years
In the journal.
for the Wall Street Journal, I decided that this would make I hoped an interesting book and would contribute something to what people know about the different legal world we've lived in since 9/11.
So the focus of the book is on the courts, the military commissions that arose after 9/11. What was the origins? What were the origins of the military commissions?
Well, when I was in law school, military commissions or military tribunals of this sort were sort of mentioned in passing as a kind of historical artifact. So I had heard of these things that had taken place at the last time, really, in the 1940s, but they weren't. It wasn't to my mind the sort of thing that the United States was in the business of doing now. But within hours of the 9/11 attacks,
Literally hours.
Some members of the Bush administration, or people close to it, were considering resurrecting a form of military commission to try and punish enemy prisoners, terrorists who might be captured in the military response. And it didn't totally come out of thin air, because during the first Bush administration, George H.W. Bush administration, there had been some investigation into reviving a military commission to try the Lockerbie bombers, or the Pan Am 103 bombers, who were at the time thought to be hiding in Libya. And this was an idea that was floated in the Justice Department. As it turned out, the British, who had joint jurisdiction with the United States over that crime, it took place over British airspace in Scotland, were not willing to do that, and so that idea was never culminated. But the idea existed, and some of the people who had worked on it in the first Bush administration brought it back to life for the second one after 9/11.
Was there any objective proof that this new mechanism really worked to accomplishing the ends of justice?
Well, it wasn't really intended to accomplish the ends of justice in the sense that we understand the court system to work. I mean, the purpose was really, it was not conceived in the way that most government projects, even wars, are conceived, in that there is a problem, there are various solutions that are raised and proposals and considered and vetted in some way or another, and ultimately some quasi-consensus is adopted and the government moves forward with it. It wasn't like that. It wasn't like the Department of Justice or the Department of Defense or the State Department or the CIA or any entity within the government responsible for national security or law enforcement or any of the things that are related to 9/11 said, you know, we may end up capturing some people who were responsible for these attacks. We don't know what we're going to do with them. We don't believe that our regular court system can handle them. We don't believe the courts martial that the military has operated for 200 years can handle them. We need something new. Help us, Mr. President. That was not how it began. It began the other way around, as a top-down initiative from the White House counsel's office and lawyers very close to the White House counsel and the Vice President Cheney, and it was seen really it was conceived as an example of the extraordinary executive powers that administration believed had been triggered by the 9/11 attacks. And they believed that in this type of crisis, the president needs complete flexibility to do anything he believes necessary to protect the country.
And complete control.
And that means not having to worry about being second-guessed by courts or the Congress or anyone else. He doesn't want to be restrained by concern that there might be some kind of future, they probably wouldn't like the term accountability, but they don't want anybody looking over their shoulder at what they have to do. So the assertion was really that the president has the power under the order that President Bush signed in November 2001. The president has the power to establish a military court system that follows no existing body of law, that is not reviewable by any court in the world, is not subject to regulation by Congress, and over which the president has complete authority to the extent of either approving or rejecting a death sentence. And so that was an incredible assertion of executive power. And for the people in the White House, that was really the ends. I mean, that was both the ends and the means. It was to say the president's power extends this far, so anything he does short of that is also okay. And at that point, the political officials who came up with this idea largely lost interest and moved on to other things. And my book talks about what happened next, as well as the development of that policy.
Within the White House, was there any opposition to the extension of this unitary executive theory, the president as all-powerful? I know there's opposition from the outside, and we'll get to that. But within the administration, was there objection to that?
Well, the policy was developed in a way to prevent any objections from coming up. Pretty much anybody in the government who was thought to be wobbly on this idea was excluded from developing it. So as it turns out, for instance, the CIA director didn't know about it until he heard about it on the news. The Secretary of State did not know about it until he heard about it on the news. There was, and this type of, and that's how the Bush administration liked to operate, to keep things extremely close hold, prevent any kind of dissenting views from coming up, because they view that as weakness, as interference. They didn't view it as part of the vetting process to try to come up with a better result. They knew the result they wanted, and allowing the process to drag on was a problem as far as the people in charge were concerned. So that actually had consequences down the road. For instance, the CIA, which ended up playing a very big role in dealing with enemy prisoners and suspected terrorists, never trusted military commissions. Never, as CIA officials told me, they actually had a lot of confidence in the existing federal court system because they'd worked with it for years. They had relationships with prosecutors and judges in New York. They had used classified information in prosecuting terrorists in the civilian court system. The intelligence community, like many human endeavors, involves a lot of personal relationships and trust that's sort of built up over time and experience. So they knew who they were dealing with in the U.S. Attorney's Office in the Southern District of New York. They did not know who these mid-level military officials, reservists, people who were sort of pulled together to work on this new project, which they weren't sure where it's going to go. They didn't have a lot of confidence in them, and that led to a lot of problems down the road.
We talked about the what life was like inside the administration, and you've just described how a lot of people simply didn't know. I was surprised to read how furiously the career military people fought in defense of the law and fought against these these efforts to go outside of it. What can you tell us about that?
Well, it's there are a lot of dimensions to that conflict that the book describes. One of them you can look at really this way: is that military justice for most of its history was not really a highly respected part of the legal structure of this country. It was basically a disciplinary tool for the Army. It wasn't something that held up the high standards of due process and fairness that we expect in most courts, because it actually developed for a different function. It was to maintain order on the battlefield and quickly deal with disciplinary problems. After World War II, a number of things happened that significantly professionalized and improved the quality of military justice. The Uniform Code of Military Justice was adopted in 1950.
Oh,
50,
I didn't realize it was that late.
Yeah. It replaced a previous body of law known as the Articles of War. The Geneva Conventions were adopted. There were major reforms in the late 1960s and in the early 1970s. And by the turn of the 21st century, the military justice system considers itself to be an incredible example of fairness and due process. That it is very proud of its procedures, and the professional military lawyers, and as with other parts of society, the lawyers proliferated in the military as they did elsewhere, and many of the developments of due process in civilian courts that the U.S. Supreme Court and state legislatures and Congress recognized in the 50s and 60s had parallels in military justice about coercion and so forth. So you had a career professional military legal establishment that's very proud of this system. They feel that the UCMJ, the Uniform Code of Military Justice, is their scripture. They are almost the guardians of it, and they are extremely concerned about its reputation in the larger legal community. And so to have suddenly this whole thing set aside by civilian political officials, many of whom had neither military nor courtroom experience, based on a sort of philosophical or ideological agenda, was very disturbing to them. And they were concerned, not so much because these are coddlers of enemies of the United States, that could hardly be the case, but they are the representatives of military justice, and the idea that an institution to which they devoted their careers would be viewed as a kangaroo court was very, very disturbing to them. And they also had some more pragmatic concerns, such as, we don't know that anything this entity does under these rules, or lack of rules, will stand up if it ever gets reviewed by the federal court system. And we don't share the same confidence that the political officials do that the federal courts are going to completely ignore them. So that was really part of it.
The other thing that impressed me from a journalistic point of view in the book was how many people went on the record. In fact, there were very few people, it seemed to me, whom you quoted who were not on the record, and you got access to a treasure trove of documents. I was most impressed by that, so help me out for my next career as a reporter.
Well, to borrow a line from the Pentagon, we don't discuss sources and methods, Bob.
You couldn't make an exception in this one case.
But I will say this, that because this is a story that I've been covering now for more than a decade, like Woody Allen said, much of life is just showing up. You're there. I'm writing stories day in and day out. Sometimes there are longer gaps between them. I actually had a number of other main beats that I took on, but I kept over the years, including the UN and now the Supreme Court. But I kept military commissions, and so I developed sources. I gained the perhaps grudging, but some confidence from people involved in the policy, and I think that's really it. I mean, I had the opportunity, and I'm actually grateful to the Journal for letting me stay with this story for so many years and be able to develop this kind of knowledge and background and network of sources that, right now when new people came into military commissions, I knew more than they did. I knew more than the officials did because I've been following it. They would ask me questions about what had gone on.
Sure.
And so...
Did you give them the same answer that you couldn't reveal your sources?
Well, I could talk generally about things, but so I would say that is pretty much it. That as reporters, what we do, it's kind of out there, and people can sort of look at it and take it apart and make their judgments about how, whether they have confidence in one's work or not. And I think I got, I'm of course much more aware of all the things I didn't get as opposed to what's in there. But I'm glad that there's enough verisimilitude that you found it a compelling account.
Are you staying on this story? I mean, if there are things out there that you didn't get, are you still trying to get them? Is this an active part of your day?
It is in that, again, my main job is covering the Supreme Court. But yes, I mean, these proceedings are continuing. And so actually, a couple of years ago, the Pentagon made it a little easier to follow in that they established a closed-circuit feed at Fort Meade outside Baltimore, where reporters and even the general public, if they want to, can go and watch those proceedings. So I am following it. I mean, I'm not following it with the intensity we did when it was brand new. Much of what happens now is almost it's a kind of maze of procedural motions and Groundhog Day-like repetition of activity in the courtroom. So a lot of it is of what is transpiring at this point is not as newsworthy, but it will be if it proceeds and we get to an actual trial. So I am following it and write about it from time to time.
So, I mean, President Obama has basically blessed these and is continuing them. So they are going to be with us.
He's blessed them, but like many things, not 1,000,000%. He has tried to find a sort of middle ground when it comes to military commissions. For instance, he inherited them from Bush. A lot of his supporters expected him to shut these things down. He had been very critical of them while a candidate, but he left the door open a tiny smidge. And when he came into office, he was persuaded by some people in the administration, others had different views, but to just keep it as as an option for the executive. And also, it turned out, because some Republicans in Congress whose help he wanted in actually closing the Guantanamo facility were big fans of the military commission structure. So they wanted it to go on, and that was a sort of political concession to them. Not much of a concession, but it was something that certainly pleased them. But Obama did, I'd say, there are two things that really describe the way he's handled military commissions. One, he did request advice from his own new general counsel, who he's in late 2013 nominated for Secretary of Homeland Security, Jay Johnson. He asked the Pentagon General Counsel to survey the military lawyers and ask what changes would be sufficient to make them more fair. So they did pass through a number of changes in the procedures to make rules about hearsay and so on somewhat less favorable to the prosecution than they had been. So far, it's hard to see a difference in the courtroom, but on paper, some changes have transpired. The second thing he did, I would say, is that since he took office, he has not sent any new prisoners to Guantanamo Bay, and he has not authorized any new military commission trials against anyone who was not already on the list. So in some ways, and this is what some people in the administration have told me informally, they're kind of looking at this as a way to clean up a legal mess that they inherited. That this is a weird, questionable judicial system, but they were given basically a legal Superfund site by the Bush administration, just a completely toxic mess of problems created by official misconduct and all sorts of things that are going to be very hard to untangle. They're basically using this as a cleanup operation for these tainted cases. They have not added anybody to these military commissions. No one who was captured after 2004, I believe, has been identified as possibly being subject to trial. And even several people who meet the technical criteria for prosecution by military commissions who have been captured since have been sent to federal court in the mainland United States.
One of the heroes of the book, it seems to me, is a Marine Lieutenant Colonel Stuart Couch. Reading his story as it's woven through your chapters, I became quite proud of the standards that our military attorneys were adhering to. And this guy put his career on the line. Is he still in the service now? What can you tell us about him?
Sure. Well, let me, for viewers who haven't read the book, Stuart Couch was a career Marine Corps officer. He was a pilot initially, a Marine pilot. When there was sort of a demobilization after the first Gulf War, he needed another specialty because they reduced, pilots. He became a military lawyer and was a basically he was a Marine Corps prosecutor, worked on a number of big cases, and because he had an aviation background, worked on a lot of aviation-related cases. And those were often some of the big ones in the Marine Corps. So he was one of the more experienced criminal prosecutors within the Marine Corps. On 9/11, he discovered shortly after 9/11 that one of his buddies from his squadron, who had left the service, was the co-pilot on United 175, which was hijacked and flown into the South Tower of the World Trade Center. So he had sort of a personal connection. He certainly had a career military patriotic connection. And like many people in the military, he's a conservative, Southern, evangelical Christian, someone who is a quintessential George W. Bush voter, and he in fact voted for George W. Bush. I mean, he's a proud, that's someone who he viewed as reflecting his values. When he got into military commissions and began to discover the way these cases have been put together and the, in some cases, torture of prisoners that had infected these cases, he took a stand and refused to bring charges in cases where he believed the defendants had been tortured. In other cases, he refused to bring charges when there was political interference from the White House level, when he thought the evidence wouldn't support it. In other cases, he wanted to bring charges against certain detainees and defendants, but political interference had freed them because they had friends in high places that got them out of the line. So he was really an incredible example, and I think that it's really hard to think of him as anything other than a hero, because he did put his career on the line, and I did reproduce some of the documents that he put his name to when no one else was watching, and I think is really an incredible example of what a lot of people who we otherwise never hear of really. The value system that they live.
I was most impressed, and again, very ended up being quite proud that our system has people like that who'll take that kind of a stand.
I'll tell you where he's now. Since you asked, he was passed over for a promotion that I can't describe it, and he wouldn't either. To his activity in this, a lot of people get passed over for promotion in the military. Who knows why? So he retired as a lieutenant colonel, and he was actually appointed an immigration judge, and that's what he is doing now in Charlotte, North Carolina, as a U.S. Immigration judge.
Excellent. So let me switch gears here for a second. You are also the author of Squeaky, The Life and Times of Lynette Alice Fromme, who was one of the Manson girls, and you're a contributor to books on war crimes and violence. And so the question is, how does such a nice guy like you end up in developing such an expertise in these topics?
Well, when I wrote the book on Squeaky Fromme, and I wrote it when I was in law school, an interviewer asked me why'd you write, and I looked at the clips from that the other day because the book's being reissued, and my answer was Eisenhower was taken. So, and that was, in fact, there was a David McCulloch book about Eisenhower that had recently been published. Why? The Lynette Fromme book. It wasn't. I don't know that I have a particular fascination with violence exactly. I mean, part of being a journalist is that you sometimes look for targets of opportunity, and you are more interested in a story than a subject matter.
Mm-hmm.
And for the Squeaky Fromme story, what appealed to me about it was a chance to take sort of a footnote to history and blow it up into the size of the main narrative, to basically flip the perspective on a lot of events and look at a cult experience from the perspective of a follower instead of the leader, and use that as a way to go through a really tumultuous period in history. The book mainly takes place from the 50s through the mid-70s.
Charlie ever make contact with you? Manson?
Charles Manson?
Yeah.
No, he did not directly. I did write to him to invite him to sit for an interview. I didn't hear back from him, but he was aware of the book, and some members of the family intermediaries I did speak to, so I suspect he was aware of it. And I did interview Lynette eventually for the book. She said she told me it wasn't as bad as I expected. She doesn't have a lot of faith in the media, it turns out. And I read
Really
somewhere
too
else.
bad.
I read somewhere else that President Ford, who I also interviewed for the book, that someone who did a feature about his daughter Susan Ford saw my book on her bookshelf and looked at it, and there was a note in it from President Ford to Susan saying, it's not half bad. So I guess if there's nothing else that Lynette and Gerald Ford agreed on, it's that my book wasn't terrible.
Any other book plans at the moment?
At the moment, no. I'm trying to catch up on sleep. This was actually, it took many years to write this book and to sort of pull it together while holding down my day job. So, I definitely understand the famous Ed Koch question. What have you done for me lately? Okay, that's nice. That's done. What's next? I'm thinking about what else to do. But I'm also actually really, I have to say, lucky to have a great regular job covering the Supreme Court and trying to deal with, and not all the cases deal with extraordinary violence and constitutional crises and so forth. Some just deal with employment security, Retirement Security Act and so forth. But so maybe something there. I'm certainly open to ideas. Are you looking for a biographer?
Sure, and I'd be honored. I mean, someone with your credentials, I think, fits my perception of myself. So I think that would be great. All right, this has been terrific. The book is Terror Courts, Rough Justice at Guantanamo Bay, written by Jess Bravin, published by Yale University Press. I encourage everyone to read it and buy several copies. And if you've enjoyed this interview and this process, the nonprofit National Press Foundation would appreciate your support, which you can make through our handy-dandy app on our website, nationalpress.org. Jess, thanks a lot. Really appreciate it.
My pleasure. Quite an honor, Bob.
Mine entirely. Thank you all.